My name is Dennis Navende, and I'll be your programs manager for the day. This series is particularly important to us because today we host the Registrar General of the Uganda Registration Services Bureau, Ms. Masike Kanovisho. And these series are really aimed at ensuring that the public demystifies the idea of IP, but also to bring the conversation around IP to the fore so everybody else starts thinking about being able to protect their inventions. So before we start, I just needed to lay out a few ground rules to make sure that the engagement goes very well. I would request that as you log into the meeting, you please mute your microphones and make use of the raise hand feature in case you want to ask a question. We will have a Q&A session at the end of this session. If you have any other queries as the RG is presenting, please make use of the chat function. We have people on standby who will be able to record those chats and forward them to the RG to respond to. You will also be able to get a copy of this presentation after the session. I'd now like to take this opportunity to welcome Madam Masike Kanovisho, our Registrar General, to take us through the role of Uganda's national IP policy in nurturing innovation and for socio-economic development. Madam Masi, you're very welcome.
Thank you very much, Dennis. Yes, I'm ready to make this presentation on the role of Uganda's national intellectual property policy in nurturing socio-economic development. I will now share my screen. I hope it can be seen now.
Yes, it's very clear. We can see it.
Maybe you'll allow me to take off my video for now so that we have a better view of the presentation. Yes, my role is to discuss the role of Uganda's national intellectual property policy in nurturing the innovation for social economic development. What is critical for us is to note that the government of Uganda approved the National Intellectual Property Policy of 2019, and this was launched by His Excellency the President of Uganda in September 2020. This policy provides a framework and the basis for intellectual property development in Uganda, and it also codifies existing legal and regulatory framework that relates to the intellectual property. We, before the national IP policy, we only had the scattered legal regimes here and there in the different law books, but now we are glad that we have a policy that brings together all the legal, regulatory, and policy framework together. According to the National Intellectual Property Policy, the Prime Minister has a duty to play where the Prime Minister's office constituted the interministerial task force to oversee the implementation of this policy, and this interministerial task force is comprised of all ministers in the ministries that do have a direct bearing on implementation of intellectual property. The policy also sets out the multi-stakeholder steering committee that is spearheading the implementation, and this is comprised of ministries, departments, and agencies that have also an influence on intellectual property. What is important to note here is that Uganda Registration Services Bureau, as the National Intellectual Property Office, is the coordinator of the National Intellectual Property Policy. The policy lists a number of ministries, departments, and agencies that have a bearing on intellectual property. And the ministries are the Ministry of Justice and Constitutional Affairs, which plays an overall responsibility for policy implementation, the Ministry of Science, Technology and Innovation, which plays a role in ensuring that science, technology, and innovation coordinated across all the key sectors, and also promotes the role of intellectual property in socio-economic development. The Ministry of Trade, Industry and Cooperatives is also critical in this implementation, for it ensures proper integration of intellectual property in trade and industry sectors. The Ministry of Agriculture, Animal Industry and Fisheries plays the role of ensuring proper integration of intellectual property in the agriculture sector. The Ministry of Health plays the role of ensuring that there is integration of intellectual property in the health sector. The Ministry of Gender, Labor and Social Development uh, makes sure that there's proper integration of intellectual property in gender, labor, and social economic development sectors. And the other role that it plays is protection and promotion of the national culture and heritage, because they're in charge of the creatives. The Ministry of ICT and National Guidance, the role is to ensure proper integration of intellectual property in the ICT sector. The Ministry of Energy, the same, to ensure that there's integration of intellectual property in the research and development, particularly alternative, sustainable and renewable energy and technological development or advancement. The Ministry of Foreign Affairs, the role in the national intellectual property policy is to promote protection of Ugandan entities regarding intellectual property rights here and overseas. This is why we have the Uganda Police Force working with us to ensure there's enforcement and protection of intellectual property. The Ministry of Internal Affairs ensures effective policy enforcement in collaboration with the Ministry of Justice and Constitutional Affairs, which is a line ministry. The Ministry of Education and Sports ensures that there's proper integration of intellectual property in the education sector. The Ministry of Water and Environment is to ensure that intellectual property contributes to achieving the balance desired for the social, economic development and environmental protection. The Ministry of Finance, Planning and Economic Development is to ensure that there's adequate planning for and allocation of financial resources in as far as implementation of this policy is concerned. And the policy also lists the departments or the agencies that are under these different ministries that are listed that can be co-opted or engaged to implement intellectual property. As you can see from the list of the ministries, all sectors of the economy are expected to integrate intellectual property. Yes, intellectual property is a subject that has been discussed by many and on many platforms. But just to say or remind us that it refers to creations of mind, and these include the inventions that are new, inventions that have been improved, the literary, scientific, and artistic works. It protects the intangible creations of mind, the human ingenuity. Our intellectual property is that asset that has been untapped for a long time. But in Uganda, we continue to see progress in as far as intellectual property uptake or utilization is concerned. It is said that intellectual property is underutilized in business and in all sectors, because when you look at some of the balance sheets of businesses, they don't capture intellectual property as an asset, yet it is an intangible asset, and creates opportunities for companies to increase the business value or commercial value of their products. And so we need to continue to promote intellectual property at whatever opportunity that we have. Intellectual property adds value at every stage of the value chain. Maybe as I may discuss, the value chain of intellectual properties starts from the innovator, innovator in generating an invention or any work of that is eligible for protection. The next stage from generation of an intellectual property work is protection, where Uganda Registration Services comes in. The protection stage, which go through the examination and publication, and then a grant of a certificate. Then the next stage is commercialization. The commercialization of this product and utilization of the same. And maybe the other stage is the enforcement. But every intellectual property, be it patents, utility models, industrial designs, trademarks, copyright, has its core stages. For patents, look at the invention. There are issues of financing. There are issues of industrial designs or regarding product designs. There are issues of commercialization and the marketing and the licensing or technology transfer that bring out the product and service value of intellectual property. Intellectual property strategies should be an integral part in the overall business strategies of an enterprise. We've been encouraging institutions, the private sector and the public sector, to put in place, to formulate intellectual property policies within the institutions, because we have so many knowledge products that come out of those public and private institutions. We have been seeing conversations in the media about ownership of intellectual property in research and development institutions, ownership of intellectual property in universities, ownership of intellectual property in the telecoms. And without intellectual property policies, institutional intellectual property policies, sometimes it's very difficult to determine. But the beauty is that the laws, the self-contained laws that provide for what ownership of intellectual property is, and this can be simplified by putting in place the intellectual property policies at the institutional level. It is very risky today to ignore the intellectual property system. You ignore it at your own peril as an organization, as a business enterprise, as a sector. If you ignore intellectual property, ignore it at your own peril. Yes, innovation is very key to the development of every state. A country like Uganda is a least developing country. And for us to become a knowledge economy, we must invest in innovation. It is innovations and inventions that determine the successes of our business entities, our societal challenges, and the interventions that are required in the day-to-day doing of business. We have so many methods, there's so many innovations, scientific methods, marketing strategies, the informal, the traditional, the functional and non-functional innovations, and we need to bring them into the bracket of protection through the National Intellectual Property Office. However, there are factors that influence the innovativeness of any country. When you look at the innovation index of the World Intellectual Property Organization, the innovativeness of any country is determined by the number of, let's say, patents or IP products and processes that are filed at the National Intellectual Property Office, the number of research and development institutions, the universities, in this case, the academic universities, the vocational training institutions, and the investments in as far as intellectual in innovation is concerned. So in the enabling environment as well to create works, the marketability of these works. There are many factors that determine the innovativeness of any country. This section does show the process and steps of innovation. And I know many of us have an idea on how the steps are taken, because many of you are innovators on this forum or have been part of the innovation value chain. It all starts with the idea, the concept, then that requires research, and this is the generation stage, the seed, the investment, the growth, the consultation, the funding, the startup, the functionality, the marketability, the revenue growth, the expansion, and up to the viability and market acceptance of any invention or innovation. Going back to the policy has a vision, and this we want to see a Uganda where innovation and creativity stimulate sustainable economic development. And the mission is to create a robust intellectual property value chain that fosters innovation and creativity as pillars of social economic development. What I emphasize on that mission is the innovation and creativity as pillars of socioeconomic development. There are priority goals that are listed in that national intellectual property policy, and the policy of objectives. One is to establish an appropriate infrastructure for innovation and creativity, and the policy objective is to enhance the infrastructure capacity for generation, protection, commercialization, and enforcement of intellectual property, and that's the value chain that I mentioned. The policy goal number 2 is to develop human capital for the IP value chain. We may have this value chain from generation of intellectual property to protection, commercialization, and enforcement. But if we do not have the human capital, the human resources that are needed along the value chain, then there will be a serious challenge. And so the policy objective number 2 is to develop and enhance human resource capacity along the value chain. The third policy goal is to enhance utilization of intellectual property system, which leads to providing incentives for utilization of intellectual property, the promotion of intellectual property-driven indigenous technology and development and commercialization. And we already see a lot of indigenous technologies. Yesterday I was sharing that video that went viral of a Ugandan that improved the alarm system to produce some local language, and this was this is in Uganda, for people to utilize locally, and many other innovations and inventions. The policy objective number 3 is to adapt and exploit the IP-driven technology transfer and commercialization. And the last D is to ensure effective intellectual property enforcement. What is the purpose of this policy? The purpose of this national intellectual property policy is basically to provide direction on short, medium, and long-term activities or interventions that will enable all IP, all intellectual property stakeholders to effectively work together towards creating, protecting, and commercially exploiting the research results, innovations, new technologies, and creative works. We have a lot of interventions that we have proposed as institutions, as sectors, and these are categorized into short, medium, and long-term interventions. And all these are to enable us as a country to generate more intellectual property, to, as much as possible, protect intellectual property and get it commercially exploited. This policy contributes to the realization of Vision 2040 and the National Development Plan 3, uh, that has aspirations towards catalyzing the transition from an agriculture-based country to a knowledge-based economy. And like I mentioned previously, you cannot talk about a knowledge-based economy when your innovativeness as a country, when you are not investing in knowledge products. The other aspiration is promoting intellectual property as a tool for all-inclusive transformation of academia, the creatives, the informal, the public sector, and the private sector. The policy also facilitates the harnessing of intellectual property as an agent for enhanced innovation and creativity, productivity and competitiveness, the knowledge-based skills, capacity building, technology transfer, wealth and employment creation. That is almost the mantra for today's economy. And the government of Uganda acknowledges that intellectual property is an essential prerequisite for sustainable development. When we look at many developing countries or developed countries, they are what they are because they embraced intellectual property as an integral part of their economy. So the intellectual property is expected and has already done this to transform the Ugandan society from a peasant to a modern and prosperous country. And like I mentioned, and this will be seen when we all integrate intellectual property in all sectors of the economy: agriculture, industry, health, education, energy, ICT, to mention but a few. As a country, the challenges or the problem that we have is the fact that there's limited capacity for generation of intellectual property, commercialization of intellectual property, protection and enforcement. And there's also lack of a clear infrastructure, inadequate human capital, human resources. We don't have so many people that are knowledgeable in intellectual property, and the inadequate utilization of the IP system. And this is envisaged in the databases of URSB that show you the numbers of applications made for all categories of intellectual property, as well as the registrations, and vis-a-vis the population of people that are educated, the people that go through research institutions, the people that have trained under vocational systems, and so on. And for us to attain or to address these constraints, we need to embrace the aspirations of the Sustainable Development Goals, the Uganda Vision 2040, the NDP3, that are all well aligned. And this intellectual property policy is aligned to all these key policy interventions that will promote the innovativeness of this country. What are the strategies and key action? The policy provides for strategies and key actions with regard to infrastructure, access, capacity building, investment in research and development, advocacy and sensitization, creating incentives around this. But we can't do this without popularizing intellectual property. And the policy envisages the popularization, the sensitization, nationwide sensitization, publicity campaigns targeting all key players in the market space, including inventors, innovators, creative industry, academia, government officials, business community, to mention but a few. So as I conclude, ladies and gentlemen on this call, we need to join hands as we promote the uptake of utilization of intellectual property in Uganda, because we no longer have any excuse. We have all the updated legal and regulatory framework. We now have an intellectual property policy, the first of its kind in the history of Uganda. And this should provide an appropriate balance between the incentives for the or the benefits for inventors and avenues for commercialization of products and processes created by these inventors. I thank you very much, and here ends my presentation.
Thank you, Registrar General, for your powerful presentation. Of course, we didn't doubt your strength in presenting because you've been behind intellectual property for quite so many years. And I believe having the policy in place is going to address a lot of loopholes that a lot of the creatives have felt in the industry. Before we are going to go into the Q&A, my name is Provia. I'm going to moderate the Q&A, which will be for 30 minutes. You can put your questions in the chat. I'll take the question in the chat, or you can put up your hand and I'll give you the opportunity to ask the question and the Registrar General will answer. So there's a question in the chat. Let me just read it. Beingana Abraham is asking, he wants to know the intergenerational formal method of innovation meaning. I think he wants to know where innovation sprouts from, but he's saying intergenerational, maybe from time memorial to the period where we are now. Can you address that, Registrar General?
Prof, can I take on like 2 or 3 questions at once so that I answer?
Okay, that's fine. And then Derek Magezi wants to know, his question is, does intellectual property only cover ideas or innovations born or conceptualized in Uganda? How about ideas copied from elsewhere? And the third one that you're going to take on is from Bashira Babala. She wants to know, does failure to register copyright with URSB fail its enforcement? RG, you can take on those 3 and we take the next set of questions. Thank you.
I was writing. I'll start from the last one. Does failure to register intellectual property copyright invalidate it? I hope I got it right. No, copyright is automatically protected at its expression or creation. And for any copyright to be protected, it must be expressed or in a tangible form. If it is a song, you sing it. If it is a movie, you act it. If it is a book, you write it. Many people think that when you have something in mind, it is automatically protected. There must be an expression. The law requires that as long as it is your idea, it is original, and you have expressed it, it is automatically protected. But we have to also appreciate the fact that originality under the copyright system is not that it has not been done anywhere in the world. It is the originality is only determined to the extent that you have added some level of skill in that work, and that skill and effort are attributed to you as long as you're not infringing on anyone's work. If it is a song and
RG, are you together? RG, are you there? We have lost our presenter. I think she's coming back on.
sorry,
Okay.
I don't know what happened. My other gadget has gone off.
RG, maybe
allow me to proceed.
You can also turn off your video.
Can you hear me now?
Yes, we can.
Yes. And so I was addressing the issue of copyright. So copyright is protected as long as it is expressed and is attributed to you. It's yours, the work. The registration is optional for purposes of evidence, but in today's world where there's a lot of copying, a lot of piracy, it is always important that you protect your work. And it is now much more required because for you to get to use your copyright as collateral to get a loan from the bank, you not just go and present yourself or sing or present your book or your album, your cassette, at least there must be a document that shows that you own. And so the circumstances somehow will make you realize that registration is very key. But it doesn't give, I mean, if you don't register, it doesn't mean that you lose the right. You have the automatic protection, but we encourage you to register for you to benefit from your works. The second question was, does innovation, does intellectual property cover ideas? Or, I mean, if you copied ideas from somewhere else, is it acceptable? I mean, you can pick information here and there. That's why there's research. That's why there's research and development. There are many databases where you can make research and come up with good solutions. There are so many products and processes that are no longer protected under the patent system or utility model system because they've fallen in the public domain. That is because the protection of patents, for example, does not go beyond 20 years. The protection of utility models may not go beyond 10 years, depending on the jurisdiction you're in, or 7 years, depending on the country of protection. Copyright is 50 years plus, your life plus 50 years after your death. But in the USA, it goes on even 100 years. And so it depends. So you're getting ideas. I don't want to use copying. Getting ideas and making research and improving your product and process is allowable. What is not acceptable is infringing on people's licenses. If your solution is even going to engage or require utilizing somebody's patent, protected patent, or utility model, or design, or song, or something, it is required that you get a license authorization from them. So it is okay for you to get to get ideas from somewhere else as long as you're not infringing. Okay, the other question regards the history of intellectual property or intergenerational formation. I hope I got it right, Provia. Is it about the history where intellectual property started? What was the question? I could have missed it. Kindly rephrase it for me.
Okay, the question was, I want to know intergenerational formal method of innovation, the meaning of intergenerational formal method of innovation.
Of course, the methods of innovation vary from one generation to another. And these are determined by the factors that have and prevailing circumstances. So if you are asking about the methods or methodologies or the models of innovativeness, these depend on the fact that you, let's say in 100s, the levels of technology were not the same. And no wonder we had those kinds of communication tools, the transportation, the distances were covered in days, and now they're covered in hours. Communication was a bit difficult because there was postage. You had to wait for a letter through the post office or through other means. Now you can get communication instantly. The level of access to the internet was not the same. There was not even any internet. So they are different from generation to generation, depending on the prevailing circumstances. But what remains a constant is that the categories of intellectual property are still the same. The categories of copyright, trademarks, patents, utility models, service marks, traditional knowledge are all still the same. And whatever is protected has to lie within the different categories. Otherwise, intellectual property has been here for quite a long time, starting from the Statute of Anne up to now. And what has also been improving are the laws, the legal regimes that have been upgraded to suit the prevailing conditions and circumstances. Thank you very much. Provia.
Thank you, Mrs. Kojunu. We will take the second set of questions. The first question is from Mike Aboneka. How do we help Ugandans out there who have no idea that they can protect their IP? How do we help Ugandans out there who have no idea that they can protect their IP? Then the second question is from Brian Matovu. How does the policy feed into the East African community agenda? Also, how does the policy assist with IP protection across the borders of Uganda, especially among the East African community? I can repeat it. How does the policy feed into the East African community agenda? And also, how does the policy assist with IP protection across the borders of Uganda, especially among the East African community? And the third question for you is from KB. For us in ICT, we write many programs, but when we make presentations, our ideas are copied. Does this imply copyright infringement, even when we didn't register with URSB? Registrar General, you can take on that set of 3 questions and we go to the next.
Thank you very much. The first question on how Ugandans can be enabled to embrace intellectual property and IP knowledge. These are efforts of communication. We have been running campaigns on a daily on how to protect intellectual property. And we have also established regional offices to support and registration offices in the different municipalities. We are online, we're on radio, we're on TV, we're on social media. We have a website that has a lot of information on intellectual property and the procedures. And so it is a concerted effort. We want all of you to be champions of intellectual property. Those that are here, those that are outside there, and the reason that we are also broadcasting the same and that knows and appreciates intellectual property. The question on East African community and the intellectual property policy. We know that intellectual property is territorial in nature. The laws, the policies do apply within the boundaries of the country that created it. But the beauty is that the protection of intellectual property is through the national laws, that is the national route, the regional laws, which are under the regional African Regional Intellectual Property Organization. Those are the protocols that help us register our patents, utility models, designs, and trademarks. And we'll be coming up with also voluntary the instrument to register and protect information relating to copyright as well. That is the regional. And then there's the international route where you register through the World Intellectual Property Organization agreements, treaties, and protocols, basically. So the East African community does have the different countries, and all these countries have their own laws. And if you want protection, if they are members of the World Intellectual Property Organization or the African Regional Intellectual Property Organization, then you can do that omnibus protection where you designate the country you want protection. But otherwise, you will have to file these protections within the different countries of East Africa. The East African region has also had efforts with regard to the protection or coming up with a framework or policy on intellectual property. And it hasn't been concluded, but as soon as that policy is out, then it will also speak to the different policies and laws of the country, of the different countries. Just give the framework of the protection of intellectual property, but within the local laws of every country. And so our national IP policy is a policy that relates to Uganda, within the boundaries of Uganda, within this territory, and the East African policy can always come in to enhance the message at the East African level. ICT programs, ideas, copied, and so on. Well, they are products and processes in terms of scientific, in terms of applications, in terms of literary, in terms of other aspects of intellectual property that can be protected, and ICT products are mainly protected under the copyright system as artistic and scientific works like computer programs and so on. But if they have a component of the hardware and to come up with that, the software requirements are protected under the copyright system. But if they have an element of the hardware, these are protected under the patent system or the utility model system, depending on the application. So if you have any new solution that does not infringe any persons, you, the creator, you, the inventor, you're advised to approach the URSB offices for support or advice on the protection scope. But if you are also working for an ICT firm and your work is to develop applications, your work is to come up with those solutions, then the ownership automatically falls within the firm that is employing you, unless you're doing a consultancy, because the ownership also varies depending on the rules of engagement. I thank you.
Okay, the third set of questions: what due diligence should an artist take after expressing their song in regard to the new IP policy, so as to maximize their revenues from copyright protection? What due diligence should an artist take after expressing their song in regard to the new IP policy, so as to maximize their revenues from copyright protection? And then the second is, there's a section of creators who think that URSB should be involved in negotiating payment of royalties for persons and entities that exploit their works. Some often have gone to courts of law and sued URSB for not doing this. What is your advice? Then the third question is that is the IP policy aligned to the law, or is there a need for harmonization of the two? RG, can you take those, and then we go to the next?
Thank you very much. Artists and due diligence and what we can do in terms of the IP policy. The music artists are advised that when they create their songs, they should go ahead to get them protected for them to give them commercial value. Because we talk about protection and commercialization of intellectual property. And so the role of URSB is to make sure that the registration system is enabled for every applicant, and here, because it relates to songs, for every artist, for every musician. And as long as they have created these songs, they have come up with these songs, it is always advisable that they protect them through registration for evidential purposes, but also for enabling them to access finance by using them as collateral. We also encourage artists to belong to collective management societies, and in this case, the Uganda Performing Rights Society, which is for performing arts. You need to belong to this so that you get the benefits of collective management, since you cannot always manage these rights individually. It's very hectic, it's very costly, and when you belong to a collective management society, you are enabled to collect your royalties through the users of your works. The second question, creators and negotiation and the URSB role. Well, these are private, intellectual property is private. These are private rights. And when you're negotiating your land, nobody comes in. You don't invite government. If you're selling your land, if you're selling your car, when you're selling your phone, your computer, the government is not engaged because it is your private right. So the same way, when you're negotiating payments for songs, why do you want the government to come in? It is your song, it is your private right. So you can sell your rights the way you want, you get your economic benefits. So we can only come in when your rights are infringed or when they are not protected and we are seeking to protect them. And that is it. But you can also guide on the contracts, the types of contracts that are you can use to protect yourself and safeguard your works. Then the last one was alignment of intellectual property policy, the national intellectual property policy with the laws. Definitely, we have had all these laws in place. And by the time we developed this policy, we did all levels of consultations, including the regulatory impact assessment, and we aligned the policy to all the laws that impact on intellectual property. And we did not stop there. We also looked at all policies that affect intellectual property. And so all these are aligned. The National Intellectual Property Policy is well aligned to the laws, the regulatory framework, the policy framework, international, regional agreements, treaties, and protocols, and the policy documents, which are the Vision 2040, the National Development Plan, and also the the Sustainable Development Goals. Thank you.
Thank you, RG. If you're losing your breath along the way, please feel free to pick choose on any of the team to support you, and so that you don't feel very strained. Then we have
Yes, anyone can put up their hand to respond to a question that has been posed. So feel free
Okay. The next set of three questions. The first question.
feel free to bail me out.
Okay, that's good. I'll pick them on RG. Moses Baguma asks, Section 1053 of the Companies Act 2012 recognizes IP as an asset that can be collateralized for finance. In this view, why aren't businesses utilizing this to access finance? Why isn't the practice of use of IP assets for finance picking up? Very good question. Chironji Joyce asks, if one registers at a repo, do you also need to register here? Brian Matovu asks, from the presentation you gave an example of the alarm system from Katwe. Could it be that it's the mode of communication that is hindering most of the ideas in areas like Katwe to be protected? These guys don't understand too much of the English we speak. Is there a plan to assist them, especially within the policy? Aradi, you can take the three as I look for someone to also help you with to back you up.
Okay. I hope, please, IP experts, IP asset financing. Yes, it's a concept that has not been popular or not been embraced by many of our economies. But Uganda is so blessed to have a legal and regulatory framework that enables to use intellectual property assets for financing or for accessing affordable finance. So we have the law. The law has been here. The Companies Act of 2012, the Security in Movable Property Act of 2019, or at least enhances this model. And so we've been promoting the use of intellectual property as collateral for the last 2 or 3 years, and we want to encourage all people on this call to embrace it. And so the legal framework is there. We just need to market it more, and the financiers are available. The alarm system in Katwe, you're talking about the language barrier. I hope I picked it. The Juakalis, the local innovators have protected. We have so many protected assets, IP assets that belong to our local innovators, a number of them, but we can do much more. And what we have done as an office, we're using a proactive approach where when we see something on the media that is being flouted to be an innovation or an invention, we reach out to that person and encourage them to protect. And this we have done ably well. And so if you have any information of innovators out there, we can always reach out to them and guide them on how they can protect their inventions and creative works. Thank you.
Okay, the next set of questions, the first question is from Leon George. Is there an online portal for registering IP? I'm in the process of developing such a system and I may need help with the URSB. Then the next question is from Kenneth Bagarokayo. Is copyright or IP registration worldwide? For example, if I copy something made in China and make it here using local materials, can I register that IP or copyright with URSB? Then the last one from Bashira Babala. It's reality that most Ugandans whose innovations the laws are supposed to protect are illiterate and find it difficult in registering the IPs. That can't be simple. Can't there be a simple, okay, wait, I'm struggling with that. Can't there be a, okay, I lost that, just a minute, I lost that.
Okay, Prof, thank you. The online platform for registration, regarding the online platform for registration, yes, we receive the applications through the email that has always been shared with the public, and it can also be shared in the chat room. But we have been working on a solution where all IP applications will be received through an automated system. So I think one of these will be rolled out in the next 1 or 2 weeks. So we have a system in place. So there's no excuse. You can always submit through the emailing system, but we are working on an automated system that should be ready anytime. The copying in China and doing your own, using your own materials. Well, I don't want to use the word copying, but well, it's research and development. If you want to improve a product or a process, it is okay. It is as long as you're not infringing on anyone's product. We have innovative minds. If we were to let's use an example of the telecommunication devices. The old telephones that were used to roll and they make noise. There are no mobile telephones. If somebody did not come up with a mobile telephone, where would we be? So there's always improvement, and that is why we utilize and promote the utility model system. It improves the existing devices, processes, and products to suit within the current levels of development. So it is okay. You can utilize some information as long as you are not infringing on anyone's product. You can use any material as long as the creation is attributed to you. As long as there's some level of skill, there's some level of effort not to take somebody's work without licensing, without any payment. I think that's it. Did I miss any other? Over to you, Provia.
You skipped one question that has been sent again. The one from Kirunji Joyce. If one registers at a repo, do you also need to register here? And then a question from...
Oh, okay.
Yeah, first take that and then...
Okay. I talked about the three routes of registration of intellectual property. And the question here is, if one registers at a repo, do they need to register here? If you have designated Uganda as a country of protection, it is okay. It is protected. But it is always advisable that before you go to a repo, you can first secure your intellectual property here at home and have that certificate. And the laws, the protocols provide that whatever is registered under the repo system is as good as being registered here in Uganda, because we are parties to these protocols and agreements. So you can select or elect what you want to use or the protection system that you want to use.
Thank you, RG. There's a question from Kirini Salim. The legal framework seems spot on in terms of protecting rights of potential IP asset holders. However, I think more work is needed in popularizing this protective framework to the ordinary Ugandans. This will certainly stimulate innovation. I thank you, RSB, for the great work. I think that was a vote of recognition of what we are doing. Let me just pick on another set of. We are almost coming to the end of this call, but let me just kindly respond to this, RG. Most Ugandan innovators may not qualify for patents, but may qualify for utility models. Explain how utility models work. RG, I think you take that. That should.
Thank you very much. Yes, the patent system and the utility model system are similar, but the utility model system has less stringent requirements. It may be called utility model or utility patent or petty patent, depending on the laws of other jurisdictions. But in Uganda, it's the utility model. Utility models are those inventions that improve, that are incremental, improve what is already in existence, or that may not meet the patentability three-step requirement of something has to be new, because for you to have a patent, it must be new. And newness here means that it must not have been done anywhere in the world. There must be an inventive step. It must not be obvious to the person that is skilled in that technical area. If you're an engineer, it shouldn't be obvious to an engineer. And it also must be relevant. In other words, it must be usable. You don't come up with a patent and keep it on the shelf, because there are also provisions under the law that require you to put it out there for purposes of functionality. And the patenting system protects the functionality of any product or process. So when it comes to utility model, it is less stringent. You may not meet one of the requirements, but it is an improvement to what is existing. And so within the least developing countries, within the African context, we may not have a lot of capacity to come up with as many patents or for products and processes to meet the three-step test of patentability. But we can very easily meet the utility model system requirements. And like I always promote, utility models are best suited for the African context or for the least developing countries. And we must promote them, colleagues, because these are incremental. You're improving what is already in existence. Your simple innovation, simple invention, simple solutions to our local problems. And these are the ones that we should look at. I'm not saying that we should not look at big inventions where there's that require big manufacturing capacity, some specified expensive investments or human capital skills. We can start small and look at the solutions in agriculture. Go to the garden, look at the problem. We have been using this hoe on a daily. How can we improve this hoe that when you hit the ground, it clears like how many meters? Those are the utility model engagements that we need. If it is new, it may qualify to be a patent, but we have had a hoe before. That device of removing soil and planting. Look, go to the health sector, go to the education sector. What solutions do we have? Do we still have to use the chalkboard? Do we still have to use, I see people using now the whiteboard. So what solutions can you offer within the communities where you come from? And intellectual property, actually, especially the patent system and utility model system, was developed because there were challenges in our communities. Every patent, every utility model is there to solve a challenge. If we had no airplanes, I don't know how we would be traveling. If we had no borders, if we had no cars, if we had no bicycles, we have communities that face challenges with transportation to medical facilities. They cannot afford an ambulance. Maybe they don't have a linear in their community. So what they do, you can come up with a tricycle that has moves on maybe that does not require fueling or consumes water or milk, depending. So these are things that these are solutions that apply and solve our local challenges. So let's not look far by looking at things that are in the abstract, that you have to look at the biggest thing and you come up with a solution. Look at in your community. The women are fetching water every day, walking miles and miles. As long as they're not enjoying it or using that practice, that can be a cultural practice, by the way, of walking to the wells, and maybe along the way you're talking to your people, you're learning, it's a way of relaxing or doing gymnastics at a local level. But if it is not affecting any cultural beliefs, and you can bring the water closer by using any devices to pump water to the people's homes. You may not need to do the piping. So look at the problems that we have in our society and encourage people to come up with solutions, but also don't stop at encouraging people to come up with those utility models. They can also protect them with URSB for them to get them recognized and protected.
Thank you very much, Registrar General. We have come to an end of our engagement. Thank you for being very elaborative, and thank you for sparing time to educate us. Every day is a learning day. I would like to thank all our participants for having been patient with us. It's a Friday. I know you want to go and unwind and listen to His Excellency, the President. I request you all to keep it locked in on our engagement series every Friday. There will be every Friday for 1 hour. Thank you for sparing your time, and have a good evening. God bless you all.
Thank you, Pravia. Thank you, everybody.
Bye.
Thank you. Bye-bye.
Cheerio.
Bye.
Bye.
Bye. Have a lovely evening. Bye-bye. Thank you, everybody. Bye.
Nice program. Nice weekend.
Thank you, Pravia. Thank you,
Bye.
Reggie. Bye. Thank you,
Bye.
members, for attending.
You're saying bye to me.